Please, Your Lordship.
Yes.
Already in item number 4, we have filed a IA to bring subsequent event on record and craving leave from the court to file an additional affidavit. So that IA has been filed today, and let that IA be called for in item number 4.
Who has filed the IA?
We have filed a petitioner. Petitioner has filed an IA
Okay.
seeking leave of the Honorable Court to bring additional events on record, because the affidavits were exchanged.
Okay. And that is not listed today.
That has been listed. Item number 4, we have filed the IA today.
Okay.
So that
So
let
what
the
do you
IA be
want?
called for on record from the registry.
Okay.
When
It
the
filed today only.
Yes, when the matter may be
Okay.
taken
Just
up.
call for the IA. Yeah. When the matter is called.
Oblige,
Yes.
madam.
Maybe my lady. In item 15, I filed my affidavit in opposition today.
Item 15.
15, hearing.
Yes. So you need some time.
My Lord, I pray for 3 times to file my reply.
Reply. Learned Counsel for the respondent number.
Sole respondent. Sole
Sole
respondent.
respondent has submitted that he has filed his affidavit in opposition. Stop. Learned Counsel for the petitioner, Mr. Quashing prays for 3 weeks' time to file his reply to the counter affidavit filed by the respondent. Where is the Lord? This is the matter of the 3 weeks.
Yes, ma'am.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 4 and 5.
4 and 5. 4 and 5. It has been just mentioned. Let it come up. Let the matter reach. Yes.
Lordship, here, this matter will come up next week.
Mr. Zoeb is my learned friend, is appearing.
He's in this
I think.
post.
Let the matter reach and then we'll pass necessary orders. You just wait, okay?
My only request to my learned colleague, my senior, was I'm down with an influenza, my lord. So if it can be on the coming Monday. I'm down with H3N2, which is an influenza, my lord. If it can come on Monday, because my voice is practically gone today.
No, it's okay. That is over. He is unwell. So we definitely only one prayer is being made, because as we filed an IA today, so
It's okay. Okay, I'm adjourning it then. You want 1 week's time?
but
Half of?
Following Monday on behalf of Enforcement Directorate, my lord, due to ill health of the arguing counsel.
The other respondent is also asking for time. I
No,
think.
she's along with us, I think. Only.
Oh,
There
okay.
will be one effective respondent.
Okay. Learned Counsel for the respondent, the Enforcement Directorate has submitted that he is indisposed today and would seek adjournment to be listed when? Monday.
Following Monday, my lord, if it's convenient to my learned friend.
No, it's up to Mr. Das also.
That's what I'm checking.
actually we have filed an IA. So being certain consultant. On Monday
you
the
served
IA will
copy?
be taken.
Have
It's
you
okay. I will serve.
Okay.
Already served.
Or if the IA can be served on us today, we will come back with some.
It has been
Yes,
served.
we
It has
serve.
been
We
served
already have
and-
served. We already have served.
Very good. Then the 6th, if it's convenient, 6th, which is a Wednesday.
to be
When
listed
is it?
on
1 second.
6th.
Photo tahap nahi.
6th August is
I think
convenient.
4th is Monday. Now the road condition is not so
Yes,
good.
yes.
So very difficult, because coming from Gauhati.
I therefore suggested 6th, Mr. Das.
No. What I am saying that if it is on Monday, Sunday we can come down from there to straight to Kohima. Otherwise we stay in Dimapur. Now what we have seen.
No problem. Monday,
Back.
no problem. Monday is fine.
On 4th,
My IA can be taken on Monday
4th
also.
August. So, Learned Counsel for petitioner states that he has also filed an IA bringing on record certain new developments.
No, liberty of the court to file an affidavit.
Seeking liberty of the court to file an additional affidavit. So, list the IA along with the main petition on 4th August 2025, and the copy of the same shall be served on the Learned Council for the respondent during the course of
We
the
served. Already we have served.
It is stated that delete that copy of the IA has already been served on the respondent. So,
My lord, for completeness,
Yes.
we had moved an early disposal, which was allowed and it was listed today. And only due to my ill health that I'm seeking an accommodation. Otherwise, we have urgency, my lord. I fell quite ill. That therefore, my lord,
Court
my
has
lord
already
had,
stated that you
on
are
the,
not well.
yes, on the last date, my lord had noted for final disposal. If my lord can note that, that will be great.
Okay. This censor research, stop. An endeavor shall be made to dispose of the matter on the next date.
Deeply obliged, my lord. I'm so deeply obliged. And I'm grateful for the accommodation today.
Yes, any problem?
Yes,
Mr.
3,
Das?
there is an interim order already. In continue.
Okay. Interim order passed earlier shall continue till the next date.
Obliged.
May I please,
Yes.
may I please, Your Lordship. Your Lordship, may I be,
5, item number 5.
Same, this is analogous.
yes.
Yes, 4 and 5, same order. Yes.
IA also will be taken up on
Yes,
that.
yes. We
IA.
have already said
Yes.
IA will be listed
Taken
along
up.
with the main
Yes,
case.
yes.
may I be pleased to make a mention of
Yes.
other item, Your Lordship, 11. Your Lordship, I have a hearing sitting in the court one. So if you can kindly accommodate me to mention this item, 11. I have an instruction to appear for all the contemners, Your Lordship.
Okay.
So my appearance may be entered, Your Lordship, some time may be granted to obtain instruction.
Learned Counsel, Ms. Livika has submitted that she has received instructions to appear on behalf of all the respondents, and she has prayed for 3 weeks' time.
Yes, Your
3
Lordship.
weeks' time to file her affidavit in opposition. So, where's the petitioner? Petitioner is not present. Learned Counsel for the petitioner. Learned Counsel for the petitioner has no objection. Stop accordingly. List the matter after 3 weeks.
Much obliged, Your Lordship. Yes, Your Lordship. I may also be allowed to mention item 12, Your Lordship. Here I've received instructions to appear on behalf of the contemners, so I may be allowed some time, Your Lordship, to receive
Learned
instructions.
Counsel in our lead submits that she has received instruction to appear on behalf of all the respondents.
Yes, Your Lordship.
Of all the respondents, and accordingly she prays for 3 weeks' time to receive instructions and to file the counter affidavit. Stop. Learned Counsel for the petitioner is present. List the matter after 3 weeks.
Much obliged.
Yes.
Yes, Lordship. Lordship, in item 11, if we may be given time to file an IA for implement, since respondent number 1 has retired. Item 11.
11.
Yes, Lordship.
Okay, item 11 again. No. You just add one more line saying Learned Counsel for the petitioner has also prayed for permission to file an IA to implement the new incumbent who has since the old, who was he, the old one?
Asna Kitar.
No, the Commissioner Secretary.
Yes, Lordship.
And what respondent number?
1.
As the respondent number 1 has already retired from service, the petitioner is allowed to file IA for implement. Yes, file it.
For motion, item number 1.
May I please, Your Lordship?
Yes.
This instant IA is filed for implement of respondent number 3, the Home Commissioner, Shri Abhijit Sinha IAS. Lordship, during the pendency of this present contempt petition, the respondent number 1, Shri Payasan RIAS, the Home Commissioner, has been transferred and the new incumbent has taken charge. So if Your Lordship may be pleased to allow to implement with Shri Abhijit Sinha IAS as respondent number 3.
What Learned Counsel for the petitioner / applicant, this application has been filed praying for improvement of Shri Abhijit Sinha, the present Home Commissioner Nagaland, as respondent number 3 in the connected COP number 3 of 2025. Stop. Learned Counsel.
My
will
ladyship,
allow-
my ladyship, I think the present incumbent is Anup Kishki. Huh? Not,
Oh, the new Home Commissioner. Who's the new Home Commissioner? Government advocate will know.
and then, and then the new incumbent also.
Then you'll have to file another application. You better withdraw this.
Yeah.
You withdraw it. Just read the Learned Counsel for the petitioner prays for withdrawal of the present IA with liberty to file afresh. So prayer is allowed. The application is disposed of with liberty to file afresh. You clarify first who is the new incumbent.
For admission, item number 2.
May it please my lordships.
Yes.
Lordship, I beg to point out order dated 24/7/2025 that was passed by this honorable court. In spite of several direction for personal appearance.
Compassionate appointment.
Yes, Lordship. 24/7/2025.
Did not appear as per the direction of persons. Yes. Where are they? Respondent number 2 and 3.
My ladyship, the respondent number 2 is present today here.
Okay. Yes, Mr. Sharma. Just give a date by which you can comply with the order. That's all.
Lordship, it is
Because-
pending with the P&AR department and the government, not at the directorate, at the PHQ level. So I cannot commit on behalf of the government, the P&AR and the Home Department. I think the best people to
When
commit.
was the order passed? The single judge order? Single judge order?
27.
This court's order?
This court's order is 24/7/2025. Just on Friday. Last.
No, the direction to appoint the petitioner.
The direction was, the first direction was passed on 3/4/2025,
3, 4.
personal appearance.
No. I'm talking about the direction of.
Direction was
board.
order number 14.
In the
dated-
writ petition.
Yes, 14/2/2020.
14 to 2020.
To be, yes, to appoint the petitioner within 2 months.
So it's now 5 years.
My ladyship, I'll clarify on that.
Yes.
The writ petition was disposed of on 14/2/2020.
Yes, 14 to 2020.
Yes, earlier, a unity list was prepared as per the unit wise. Now, an addendum was issued in 2019, where it says that the appointment on commissioner has to be in order of that of that. That of that. So we have come up with a centralized unity list. And then wherein the name of the petitioner was figured as serial number 60.
60.
Initially.
And then the list was 21/3/2022. Now what happened was the petitioner again challenged that
Oh,
unit list
okay.
by filing another writ petition 115 of 2023. 2023. Now, this court has disposed of the aforesaid writ petition by order dated 5/7/2023, setting aside the subsequent list which was prepared wherein the name of the petitioner was figured as number 60. Now, and then this honorable court has held that the attendance should be read prospectively, not retrospectively. Now, after the court's order, we have come with a new list wherein the name of the petitioner is figured as serial number 2.
Serial number 2.
And then there's another fellow who is at figure number 1. So we have sent the proposal to the government on 4th of June 2024 for approval of the serial number 1 and 2. There is subsequent development.
So, as far as respondent number 2 is concerned, the proposal has been sent to the government on 4/7/2024.
4th June.
Or 4/6.
Yes,
4/6/2024.
We have already placed the reports on.
Okay, that is there on
Yes,
record. Just show me, just take me to that proposal sent to the government. No, is it here in your reply?
Yes, ma'am.
It's, just give the reply, paging, the page of the reply.
No, my lady, she was placed as on which sheet? The newspaper.
It's not annexed in your reply.
It was accepted.
Have you seen this letter dated
They
4th
sending
June
to the
2024?
government, that is within my knowledge, Lordship.
And the respondents are Respondent 1, T. John Lockham, number 2, Director General of Police. So many affidavits. You have not impleted the PNER Home Department, the
No,
Principal Secretary.
No, Lordship. I have implemented the respondent number 2 and respondent number 3, that is Home Commissioner. It is within the authority, Lordship.
My lady, this is the letter which was sent
Yes.
to PNF for examination.
Last one.
The last one. Once the clearance is given by the PNF, we will do the necessary.
Okay. Just in compliance of the direction passed by this court on 24/7/2024, the respondent number 2 is present in person before this court. Stop. Respondent number 2 has stated that the proposal for appointment of the petitioner on compassionate ground has been forwarded to the Home Commissioner via letter dated 4th June 2024 from the Office of the Director General of Police, Nagaland, Kohima, and accordingly the matter is now pending with the government. Stop. The letter dated 4th June 2024 has been produced by the respondent number 2. Stop. Another letter addressed to the Additional Advocate General, Nagaland, from the Home Department dated 15 July 2025 has been placed before this court, by which it is stated that the Home Department has received the requisite documents from the police headquarters and the matter has been submitted to the PNER department for necessary examination, and the outcome of the matter is awaited. Stop. In view of the various communications as stated above, this court is of the view that the respondent number the presence of respondent number 2 may be dispensed with for the time being, and accordingly his personal appearance is dispensed with. Stop. as the respondent number 3 is not present. Yes.
In fact, this matter is not actually handled by additional GMT, but because of the bereavement, he could not make it. The respondent number 3 is actually on his way. He got stuck up the traffic jam, Your Lordship, but he's on the way to comply with this order, Your Lordship. But however, Your Lordship, having said that, Your Lordship, the order dated 24/7 to 2025 if we see, Lordship, this is against the former Home Commissioner. There is the present Home Commissioner actually is not even included in the present contempt petition, my Lord.
No, he has been implemented.
The Lordship may kindly
No,
peruse the order.
the present
24/7 2025. It is in the name of Sri Vishant R, Home Commissioner.
He was respondent number 3. Now the newly incumbent, that we have to implement. However, Lordship,
That has not been implemented.
no,
Your Lordship.
we have not implemented because we are just hearing from this honorable court. So he may be implemented. We will implement if necessary. However, this order was pertaining to his tenure, and he is still respondent number 3.
Learned Counsel, the letter from PHQ was sent to the Home Commissioner on
Yes.
4/6/2024.
Yes.
So at that period of
At that
time,
period.
respondent 3 was still there.
Yes,
Lordship.
exactly.
Lordship.
So he also has to explain. So we will
Lordship,
call the matter after some time. Let him explain. Okay.
Lordship.
After he reaches. Yes.
Lordship.
We'll call after some time. Your appearance is dispensed.
My ladyship, if
Yes.
respondent number 2 may be allowed to leave.
Yes, yes. Already dispensed.
For admission, item number 3.
May I please, my ladyship?
Yes.
I've been instructed to appear for respondent number 4. I'll be filing my power within 1-2 days.
I'm appearing on behalf of PB Chetri, the appellant.
For appellant. Learned Counsel for the appellant, Mr. Rizal is present. Stop. Learned Counsel, Mr. Futsako has submitted that he will be appearing for respondent number 4 and has asked and has prayed for some time to file. You have filed your vakalat, nama?
No, I'll be filing my power within 2 days.
Okay.
1-2
And has
days.
prayed for some time to file the vakalat, nama? Stop. Accordingly, here's the matter after
2 weeks, Your Honor.
after 2 weeks.
Bless my lady.
May I please, my Lord?
Yes.
Respondent number 3 in the previous contempt petition has arrived, my Lord.
Okay.
Yes.
Yes, we are on this contempt petition where a direction has been given by the court to appoint the petitioner on compassionate ground. And the PHQ has already sent the proposal to the Home Department on 4/6/2024. So what happened after that? Why has it taken so long?
After that, I think some documents were missing, but we have received them now, and I have already forwarded it to the PNAR. We will soon be doing it.
So you'll have to give an undertaking. Within how many days or how many weeks you can do it?
We should be able to do it within a month. Whichever. I think maybe
Because you cannot sleep over the court's
Yes,
order
ma'am.
like this. It is a 2023 matter.
Yes. So
1 month.
maybe within a month, yes, should be able to do it.
The
Lordship.
continuation, yes.
It may be kept in knowledge that 1 month, always 1 month has been granted to the respondent,
Ah,
and now it is already 20.
He is giving an undertaking before the court, so he will comply.
I just want to
And-
assure the
and
court
this
we are
is a-
seriously working on it, and hopefully we'll get it done.
And this is a contempt petition, it's a continuation of that earlier order, okay? Respondent number 3, Mr. Anup Kilchi is also present before this court. Stop. He has submitted that the department is seriously processing the matter of the petitioner and prays that he may be given 1 month's time to comply with the direction of this court. So, since it is the undertaking of the respondent number 3 that the case of the petitioner shall be considered within a month's time, the prayer is allowed. List the matter after 1 month.
A fixed date may
Stop.
be given, but
Yes. Today is 28th, so first September.
I give it to your
1st
lordship's
September, 1st
fixation.
September, yes, 1st September. So it is expected that the respondent number 3
Get it done well.
shall comply with the order of this court within that time. So the personal appearance of respondent number 3 is dispensed with for the time being. List on 1st September. Yes, 1st September.
Obliged.
Thank you.
Sorry for just troubling your lordship in between.
Yes.
The item which was taken by your lordship for item number 3, 4 and 5. Can it be, because I have taken the consent of the council and Delhi also. So can it be on 11th? Because next week High Court is, Arunachal new High Court is opening also. I think on 9th. So it can be on 11th. I have taken the consent of the other side also. 11th is Monday.
Yes, it's okay.
11.
But what does High Court inauguration has to do
No,
with this?
nothing, but I have to be there also.
Oh,
That is
okay. 11th then instead of 4th. Earlier we had fixed on 4th.
4th.
11th.
Sorry for troubling. I informed the other side from Delhi also. I have informed.
For admission, item number 6.
May I please, Your Lordship? Lordship, on the
Yes.
last occasion, this Honorable Court has directed to produce the case diary, Lordship.
Yes.
In fact, we have
It has come.
submitted the Lordship.
Only the status report was sent, which is
On the last occasion, we have submitted the status report, but however, this Honorable Court has directed
commercial
us.
quantity.
Lordship is a commercial quantity. However, Lordship, on the last occasion, as far as the from the status report, it transpired that accused number 2, who is the petition, who is bring before the dishonorable court for bail application, Lordship. Lordship, in the status report, it has been mentioned that he is not involved, Lordship, and so therefore, this court.
Where is it? Where is that?
In the status
report.
report, I have submitted the status report on 18.
Oh, acha, yes, I've seen.
Lordship. So, in order to ascertain, Lordship, this Honorable Court has directed us to produce the case diary, Lordship.
What is the petitioner's name? The name of the accused?
Accused,
Akashi.
last paragraph. Accused number 2,
Akashi Achumi.
Lordship.
This one from Belinda to
Yes.
Prima facie, it appears that the accused here did not know about the consignment.
Lordship,
Yes.
that is what.
He was just called by the other accused
Lordship,
regarding to transport him because he didn't have conveyance.
Lordship, Lordship.
The present bail application under section 483 of the BNSS has been filed praying for has been filed by the father of the accused praying for granting of bail in respect of the accused Shri A. Dot Akashi Achumi, AKASHE Achumi. Learned counsel for the petitioner, Ms. Mika, has submitted that the accused person the present accused person was arrested on
10th of July.
10th June. 10th June, I think.
Lordship.
On 10th June 2025. Stop. It is stated that he was arrested along with another co-accused, namely Sridam Biswas, SRIDAM, Sridam Biswas, BISWAS, alias Rohit, and booked under Section 21, Clause C of the NDPS Act, read with Section 3, Clause 5 of the BNS. Stop. It is also stated that, it is also submitted that the present accused person has no connection with the seized items and he is a victim of circumstance. And he had filed a bail application being IA criminal number 389 of 2025 before the learned special judge NDPS Dimapur. Stop. However, the same was rejected by order dated 30/6/2025. Stop. Learned counsel submits that on the day of the incident, the co-accused, who is a friend and a neighbor, approached the present accused person to accompany him for some work. Stop. Therefore, the present accused, in good faith, accompanied his friend, the co-accused, to the warehouse of the courier agency at Suvima, Jumukutima. Stop. The present accused had no knowledge that the co-accused was going to receive a parcel containing the seized items / what were the seized items? Cough syrup.
Yes, Lordship. 25 cartons, Lordship.
Containing the seized items / codeine based cough syrup. Or you say 3,000 bottles. 3,000 bottles of codeine based cough syrup. Stop. It is further submitted that he had no knowledge about the seized items and he only came to know about it when the police personnel seized the consignment. Stop. It is further stated that nothing was seized from the possession of the present accused person. Stop. It is also submitted that the accused is a permanent resident Dimapur.
Lordship.
Permanent
Long
resident.
privilege.
Permanent resident of Dimapur, and there is no likelihood that he will abscond or avoid the process of law. Stop. It is therefore prayed that the accused person may be released on bail pending investigation in the present case. Stop. Para. Learned Public Prosecutor V. Zimomi has produced the case diary. Stop. Upon going through the statements of the two accused persons, it is seen that the present accused had no knowledge about the consignment and the contents thereof. Stop. It is seen that it was the co-accused who had called him to accompany him to the courier agency to receive the consignment, and the present accused had no knowledge about the same when he accompanied the co-accused. Stop. Para. In view of the facts and circumstances as discussed above, the present accused person, Mr. A. Akashi Achumi, is therefore released on bail under the following conditions. Number 1, the accused shall execute a bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the learned trial court. Stop. Number 2, the accused shall not tamper with the evidence or hamper the investigation in any way. Stop. Number 3, the accused shall appear before the investigating officer as and when summoned and cooperate with the investigation. To dispose of.
Not obliged, Lordship.
For admission, item number 7.
Wait, please, Your Lordship. This petition is a joint petition seeking to quash the FIR as well as the connected criminal proceedings based on a compromise which have been entered between the accused as well as the complainants. Initially, an FIR was filed, which is at page 14 of the petition.
Yes, this has come up earlier also.
Yes, on Friday it has come up, but the learned PP had sought for some time to produce the case diary.
May I please, Your Lordship? My Lord, in the last occasion I was directed to produce the CD, my Lord.
Oh, it's already charge sheeted.
Yes, my lord. Charge sheet was filed on 17/1/2025. Your lordship may kindly see page number 45 in the charge sheet. 16.11. May I read, my lord?
Yes.
Investigation established prima facie and substantial evidence that accused so-and-so had published a malicious post on so-and-so in the patriotic Nagas Facebook. After the public outcry and condemnation, the accused had requested the page deletion, demonstrating a deliberate effort to conceal his involvement. Charge based on the above mentioned facts and circumstances and also oral and digital evidence, the following charges are established against the accused. So under section 352 PNS, under section 353 clause 2 PNS, and so my lord, here that as per the charge sheet, the case has been established under this section, but here under section 352 is compoundable offense, my lord, and the 353 clause 2 is non-compoundable offense.
Lordship, in any view of the matter, as the parties have compromised.
Yes, yes, of course. Let me just see the
There,
compromise. These
at page 24.
Yes, PP is a joint petition also.
Yes, my lord.
And the complainant has also signed
Yes.
in the Vaklatnama also, as well as the petitioner. Yes, heard learned counsel for the petitioner, Mr. L. Iralu, as well as the learned PP, Mr. Tipapong, for the state respondents. The present application under section 528 of the BNSS has been filed jointly by the accused as well as the complainants for quashing of the criminal proceedings in GR 157 of 2024 pending before the learned JMFC Kohima and the connected FIR arising out of cybercrime PS case number 011/24 under section 352/353 clause 2 BNS on the basis of a compromise/settlement arrived between the accused and the complainants. Stop. Fair. The petitioner number 2 and 3 had lodged a complaint with the officer in charge, Cybercrime Police Station, Kohima, alleging that a malicious post was uploaded in the Facebook page under the account name of the Patriotic Naga in inverted stop. It was alleged that the post had defamed, vilified and denigrated their leader, Dr. S.C. Jamir. Stop. It was further alleged that it has outraged and maligned the modesty of the Ao women in general, and that there was potential to threaten the peaceful intertribal coexistence. Stop. Pursuant to the complaint, the complaint case number 11/2024 under section 352/353 clause 2 BNS was registered on 7/11/2024. Stop. Para. During the course of investigation, the petitioner number 1/accused was arrested on 30/11/2024. Stop. Thereafter, the alleged accused was released on bail by the learned JMFC, Kohima, on 14/1/2025. Stop. Para. Thereafter, the petitioner number 1, along with his community leaders, approached the apex tribal body of the Ao community, the Ao Senden, on 14/3/2025 and sought for forgiveness for the conduct of the petitioner number 1/accused and to amicably settle the matter in the larger interest of the two communities. Stop. Para. Upon detailed deliberation, the Ao Senden decided to pardon the accused/petitioner number 1, subject to executing an undertaking and publishing the same in the local papers. Stop. Consequently, an undertaking was executed on 14/3/2025 by the accused/petitioner number 1. Stop. Thereafter, a compromise deed to this effect was drawn up and executed on 30/5/2025 between the petitioner/accused, petition number 1/accused, and the complainants/petitioner number 2 and 3.
Yes.
Petitioner number 2 and 3. And the compromise deed has been annexed to the petition as annexure number 1 and annexure number 7. Stop. Learned counsel for the petitioner submits that in view of the compromise arrived at between the parties, the present petition has been filed jointly by the accused/petitioner number 1 as well as the complainants/respondent petitioner number 1 and 2, praying for quashing and setting aside of the criminal proceedings in GR 157/2024 under section 352/353 clause 2 BNS pending before the court of the learned JMFC Kohima, and also the connected FIR in cybercrime PS case number 11 of 2024. Stop. Para. Learned public prosecutor Mr. Tipapom has produced the case diary, and it is seen that the petition has that the case has already been charge sheeted and is pending before the learned JMFC Kohima for trial. Stop. However, this court is of the view that it would be a futile exercise to continue with the trial, as the petitioners, as the complainants and the accused person have already entered into a compromise and have settled the matter amicably outside the court. Stop. Where, in view of the above discussion, the proceedings of GR 9157/2024 pending before the learned JMFC Kohima and the connected FIR in cybercrime PS case 11 of 2024 is hereby quashed and set aside.
Deeply obliged.
Much obliged.
For admission, item numbers 8 and 9.
May I please, Your Lordship?
Yes.
Lordship, in this matter, I am for the respondent number 1 to 4. Lordship, I am yet to receive the IA, the extra copy of the IA, for us to file objection.
Oh, this IA 58.
Lordship.
IA 58 copy. Prosecco.
Yes, my lady, I will furnish the copy.
Learned Counsel, Mr. Wabang, appearing on behalf of Respondent 1 to 4, has submitted that he is yet to receive a copy of the IA 58 of 2025 and accordingly prays that a copy of the same may be served on him. So, Learned Counsel for the appellant, Mr. Foseko, is directed to serve a copy on the respondents number 1 to 4 during the course of the day.
No.
During the course of the day.
After
This
3
is
weeks,
the matter
Lordship.
after 3 weeks.
Lordship. Obliged, Lordship.
For admission, item number 10.
Lordship, in this matter also I am for the respondent 1. Lordship, I have received the copy of the IA, so
You want
I
to
may
file
be
some
allowed,
objection?
Lordship, I may be allowed 3 weeks time to file objection.
Heard Learned Counsel for the, here you are for respondent?
1.
Respondent 1, Mr. Imti Wapang. He has submitted that he has received a copy of the IA 66 of 2025 and prays for 3 weeks time to file an objection to the same. Stop. Learned Counsel, prayer is allowed. List of the 3 weeks, Learned Counsel for the appellant. And Ms. such and such is present.
Obliged, Lordship.
For orders, item numbers 13 and 14.
Lordship, in this matter also I am for respondent number 1 to 3. Lordship, I am yet to receive the extra copy of the IA, so the appellant may be directed for us to file the objection, Lordship.
Learned Counsel for the appellant, Mr. Foseko, is directed to furnish copies of the IA 59.
59.
IA 59 of 2025 on the Learned Counsel for Wapang appearing for the respondent number
1 to 3.
Respondent number 1 to 3. Stop. During the course of the day.
Highly obliged,
And
Lordship.
this is the matter after
3 weeks,
3
Lordship.
weeks.
My ladyship, with respect to the respondent number 4 and 5, they are the owner and the driver. So,
Notice return service still awaited.
okay, then,
What to do? You
But-
want to take fresh steps or?
my lady, if the Honorable Court can direct the applicant to take steps by way of a publication, because usually in these
Did they
cases,
appear before the trial court?
for the trial court, 3 and 4, 1 and 2.
They are from Tamil Nadu.
No,
Tamil
they
Nadu.
didn't appear. Tamil
Was
Nadu.
ex-party.
So, yes, the tribunal the judgment order passed by the tribunal is ex parte against
Ex
them.
parte.
Yes. Then Lordship let it wait till next date. Next date,
Yes, we'll wait and then we'll see.
I'll take instructions and take necessary steps.
Service report on respondent number 4 and 5 is still awaited. The appellant is directed to seek instructions regarding the service on respondent number 4 and 5.
Highly obliged, my lord.
Bless my lord.
No, please, Your Lordship. Lordship, this is regarding item number 8 and 9. I, on behalf of respondent number 6 and on behalf of my senior and Likasi Sangdam. So, if Your Lordship may kindly reflect my senior name on the ghost list.
Which one? Item?
8 and 9.
8 and 9.
Yes, Lordship.
Have you already passed order in 8 and 9?
Yes. She's led by Likase.
Oh, okay,
She'll-
okay. So, MS Surgeon Sir submits that Mr. Likase Sangtam is appearing on behalf of
Respondent 6.
Respondent 6 in the present matter and prays that the name of, and therefore prays that the name of Mr. Likase Sangtam may be reflected in the cost list. Stop. So there also you say that registry is directed to reflect the name of Mr. Likase Sangtam as for the respondent number 6.
Right, Lordship.
Bless my lord.
For hearing, item number 16.
Mr. Shipri, you are for
I'm for the petitioner.
And who's for the
Actually, there's no opponent today because in spite of notices, they refuse to appear.
Refuse to appear.
They appear before Dobashi Court, Jubja. They appear before the SDO Court, SDO Civil Court, Jubja. But when we file this revision petition before High Court, in spite of notice, they refuse to come. So therefore, the Honour will appreciate.
Any order by this court?
Honour may kindly see, my Lord may kindly see, order dated 18/3/25, by which it is ordered that this matter will be heard ex parte. 18/3/25, my Lord.
Counsel for the petitioner submits some Yes, what is your
When
case?
this matter was taken up for I first filed as second appeal. But during the course of hearing, Justice Devasius Bora, he has pointed out to me that instead of appeal, better file civil revision. So therefore, I have converted this into revision. Even during the appeal, we served notice to them. They don't want to come. Then at a time on the ground, they will involve the members of the clan and threaten our group for construction. So now, in spite of our best effort to serve on them, they have refused. Yes. Now, my Lord, the present civil case, I have filed this revision against the judgment and order passed by the SDO Civil. I'll just straight take away to take Lordship's attention to this order, impugn order, page 66, which was passed by the SDO Civil, page 66. This is a short order, simple. I'll point out the infirmities here, my Lord. This is the covering letter, my Lord, page, that is dated 19 February 24. Then next, 67 is the operative. May I read it, my Lord? In the court of SDO Civil, Sechu Jubja, assistant to the Deputy Commissioner Kohima. Sechu Jubja, Thajao Sekwase versus Nyungu Mazo Nipu. There is a clan called Nipu Numia. So he represents. In regard to a dispute that arose from a plot of land situated in Tsuru Colony, Sechu Jubja, Kohima District, Nagaland, a land measuring an area of 17.47 acres approximately, bounded and guarded by North
Kho Nipu, South Rano Saija, Public Jashoke, East Rumutyo Mayese / Nola Dr. Joyce, West NH 29. The said issue and dispute was brought and addressed before my office in the form of an appeal filed by the plaintiff. It is me, my lord. Plaintiff Tejao Sekwase against the respondent Ningu Mazo Nipu. This prevailing matter was earlier taken up and heard by the Dobashi Court, Statute Zubda Kohima District, Nagaland, and judgment was pronounced by the Dobashi Court whereby the following was passed. Quote, hence, if Saleo clan take oath swearing and give the land to the Nipunuma clan, the case will be closed. The oath sworn land will be given to Nipunuma clan. But since Niele clan, this is me, also belong to Nipunuma clan, their share will also be there. Further, since Niele clan had built their houses on the land, those areas will not be touched because they are also of Nipunuma clan. But without the consent of Nipunuma clan, they will not be allowed to sell out their land or houses, unquote. In the light of the appeal filed before my office, I have perused through the appeal and the various statements and documents put on record and attributed a thorough examination of the appeal. The respondent, Ningu Mazo Nipu, appeared before the undersigned and has stated that his preceding generation elders had never taken loan from late Niala Sekwase. However, since Tejao Sekwase is also originally from Nipunuma clan, his father, grandfather, etc. was allowed to cultivate in the present plot of land which is in dispute. The right to claim ownership of the land was not given to them. Further, the Nipunuma clan would not disturb or claim the existing structures which Tejao Sekwase had constructed developed. Para 1. As accordance with paragraph 4, 5, 6, 7, 8 and 9 with regard to the land which has been developed by Tejao Sekwase. A. The late grandfather of appellant, it's me, had developed a portion of the land into wet terrace paddy fields and June cultivation was also practiced. Also in the year 1970 to 80, the appellant had constructed 3 houses in the said plot of land in which the respondent had never raised any claims or intervened with the above mentioned activities. B. Also in the year 1981, late Chutto Kusa required his irrigation canal to pass through the appellant's land and for which the appellant had allowed for the same. C. That in the year 2008, Sri Kho Nipu, Sri Remutio Setru, Sri Kunyo, and Mr. Sri Masikotyo Zene had approached the appellant several times seeking permission to construct a road to pass through the appellant's land, but the appellant had declined, and for which the leaders of Setru Jubda recognized that the appellant and his family members as the rightful owners of the disputed land. D. That again in the year 2008, Sri Kovi Mayase, the then revenue official Kohima, Nagaland, had sent his DB, Sri Kunyo, twice seeking the appellant's permission to part with a portion of appellant's land for setting up of police camp within the present disputed area, but the appellant had refused the revenue official for setting up of the said police camp. E. That in the year 2012, the state government had approached the appellant to donate some portion of present disputed land for construction of GPS, meaning government primary school, Sachu Jubda, to which the ancestors of the appellant late Niala Sekwase donated a portion of the land measuring an area of 100 by 50 feet to the government, the state government, free of cost, and a deed of agreement had also been executed dated 6/12/2012 between the village council and the landowners represented by Sri Nizole GPS Sachu Jubda was constructed and is functioning till date. F. That in the year 2013, the National Highway Authority of India for the construction of 4 land had also through publication in the local daily Chapi, inviting any persons, parties, landowners for claims and objections, if any, within 15 days from the date of publication. The appellant, along with some family members, had claimed land company against plot numbers 170 to 173. None appear from the respondent side. G. In the year 2020, the state government had sanctioned some money for constructions of water reservoir. The Zero Colony leaders and Watson committee members approached the appellant to give a portion of land within the present disputed land, to which the appellant donated 18 by 10 feet for the constructions of the same. An agreement was also executed to that effect. 2. That somewhere in the year 2014, the respondent clan had written a letter to the appellant dated 3/12/24, 2014, claiming ownership over the present disputed land. The appellant and his brother had replied in written to the said letter to the respondent. Copy of the same has been put on record. 3 is relevant, my lord. That a land possession certificate dated 16/9/2014, along with sketch map of the disputed area, was issued by the revenue official Kohima, Nagaland, certifying that the appellant is the absolute owner of the present disputed land, which was also countersigned by the chairman, village council, Sachut Jubja. 4. That also in the year 2022, for the purpose of constructions of the office of SDO Civil, the Deputy Commissioner Kohima, Nagaland, White notification dated 26/09/22 had acquired Sri Rangutyo Sechu's land, in which the appellant land is bounded in the east and north side. A notification was also published in the local daily Chapi on 27/10/22 to that effect for claims of an objection. 5. That the respondent, Nipu Nimekhel, had approached the revenue official Kohima for ratification of the land schedule for acquisition for the new office of SDO Civil Jubja, and a letter dated 27/10/22 was issued ratifying the land schedule. 6. The appellant and his family members filed and submitted a complaint to the district administration on 16/3/23, and the Deputy Commissioner Kohima had rectified the same by letter dated 6/4/23, restoring the name of the appellant in the land schedule. 7. That on 11/10/22, Sri Ningu Mezo Nipu, respondent, along with 3 persons, started cutting the jungles of the appellant's land and started claiming ownership of the present disputed land. The appellant had submitted a complaint letter dated 17/10/22 to the SDO Civil Sachut Jubja, whereby directives were given to file a complaint before the customary court, and a case was registered before the Dobashi court Sachut Jubja. 8 is relevant, my lord. The appellant, as per the directive of this court, had furnished the following details: that out of 17.47 acres approximate of the land in dispute, he has developed nearly 15 acres at the cost of 5.50 crores. The appellant also possessed land possession certificate duly certified and issued by the revenue official office of the Deputy Commissioner Kohima dated 16/09/2014. In the light of the aforesaid submission and the document put on record, I find the following questions which require my consideration, my determination. 1. Whether the appellant is the rightful owner having all rights and title to the disputed plot of land. 2. Whether the respondent has claim over the disputed plot of land. 3. Whether the respondent can claim rights and title to the developed area of the appellant. In fact, this question is wrong. That's what I have stated. 4. Whether appellant without the consent of Nipu Meklan will be allowed to sell out their land or houses. 9. Paragraph 9. In regard to the first question, the appellant's family has been in occupation for over 100 years, developing and managing the disputed plot of land. it is clear and apparent that the respondent would have objected to the development activities of the appellant from the past 100 years. However, no such claim or objection were raised or brought before any competent authority. Accordingly, I am inclined that the developed area within the disputed land belongs to the appellant, since the appellant has incurred all expenses for any and all developments where necessitated. 10, paragraph
So
10.
that is in your favor?
Yes.
Ah.
Once he has come to that conclusion, how can he pass an order that at least 2.5 acres which are not developed should be a common property then? Because title has to be one. It cannot be distinguished between developed and undeveloped land. This is
The
my
developed area within the disputed land.
yeah. So once my title is established that I have been occupying and possessing for 100 years, where is the question of
100 years.
where is the question of separating undeveloped area and give it to declare as common property? This is my case, my lord. Paragraph 10. In regard to second question, any claims of the respondent to the disputed plot of land, it is to my determination that since both the parties in dispute do not possess any document evidence pertaining to claims of ancestral land, that in concern to past negotiation and claim must be agreements. Most of the agreements, oblique deals, oblique issues, oblique dispute were executed verbally, and hardly any written document or evidences are in existence. Therefore, aside the portions of the land developed by the appellant who has also incurred all expenses and losses, let the remaining undeveloped portion of land, 2.5 acres approximately, be in a discourse between both parties or any dispute parties for any future evocation as per their customs and tradition. This is the most dangerous and harmful judgment. So 11.
In fact, it's difficult to understand.
It is
also
I have
what,
checked.
What he meant.
I have checked meaning of
Be in a discourse between both parties.
Anyway, we don't blame you. They are civil administrators. So
Any disputed parties for any future.
the most probably according to his understanding, his December courts and that honor courts understanding, out of 17 acres, I have developed 15. Now there remain 2.5. So let this be decided among the family members. This course I could understand in that way. So what? Yes.
As per the customs and traditions.
11. In regard to third question, this is another thing. In regard to third question, ample time and opportunity has been given to the respondent to raise claim and objection. However, respondent neither approached the appellant nor any statutory authority for the same. It is practical in approach that any person or persons in good sense, if having all rights ought to enact, if there arises any infringement to his rights and title, ignorance or being tacit cannot be considered a merit where there is an infringement. Therefore, the respondent cannot have any claim or waiver to any benefits enjoyed by the appellant or to any of the developed portion of the land by the appellant. My lordship has understood now. I have altogether near grandchildren, all of us. Kohima, we have 5 houses. Satsujubza, we have 5 houses. Dimapur 1. So now, when we have been possessed for more than 100 years, this is the finding of the court. Now, how can the court distinguish between the developed and undeveloped area should be left with the people of the clan members? This is my whole case, my lord. Because court has already come to a conclusion that we have been possessing the land for 100 years and we have also developed. This road is very, lordship we regularly travel on this road. Jubja, there's a box cutting road. That is the area. Above the road also I have considered RCC building.
The question is now, You have come under 115
Yes.
and 151 CPC.
And
read with 31 and 32 of the
32,
rules.
32.
So against the order of assistant to DC,
Yes.
appeal lies to High Court.
Correct. Actually, I filed appeal, but appeal filed. But when the matter was heard, Justice Devasi Bora pointed out to Mr. Counsel, you withdraw this one and file civil revision under this board. So that's why I have come again, because I have annexed the order also. The order passed by the High Court.
No. Actually, it should be under rules, because if we go by CPC,
Yes.
then this is not the regular court,
Correct,
the STU's court.
That's why I have got section 32, revision, power of revision. Rules for administration of justice. Rule 32, that is the revisional power for High Court and the Deputy Commissioner. So I have come before the High Court for civil revision under Rule 32. Any question? Since
the learned, the SDO has
Yes.
decided the title.
Yes.
And title without deciding the title, without framing issues, and without adducing evidence.
That
how can
it was started from Dobashi Court. As we all know, they don't strictly follow
No, of
CPC. So therefore, I have come under Rule 32
That's why I'm saying. That's why instead of going to the CPC,
Yes.
wouldn't it be better to deal with it as
32.
as 32
Correct,
petition?
absolutely, no problem. Yes. Because just Lordship is aware by quoting you wrong does not.
No, of course that is there.
So it can be dealt under 32. I have come to know about that.
What about the amended? There was one amendment. Oh, rules are not amended.
Not amended.
That was village council.
Yes, yes.
Village council.
Village
right.
council is that. Now, but this 37 is not yet. It will remain as it is. So practically this has to be decided under Rule 32. Revisional scope, jurisdiction for the High Court.
Kosa, you have the rules here, rules for administration of justice and police.
1937.
That Justice Real Race book.
Zell res compilation.
That blue one.
I don't know. Yes, yes, that's
Uh-huh.
Rule 32. I have read this morning. Release of date. Just get the particular. This one. I'll do.
Rule 32 after
Yes.
84 amendment.
Yes.
Isn't it? High Court or the Deputy Commissioner may, on an application by the aggrieved party, it was called for representation. So it can be an appeal under Rule 32.
Yes.
But see, your prayer portion, you have prayed for quashing and setting aside of the judgment and order.
Yes.
But then the judgment, the entire judgment and order, it is in your favor, only that particular portion.
Correct.
Then if the whole judgment is quashed and set aside, won't it be like, won't it go against you? Wouldn't it be better if this particular portion is amended or reviewed?
Prayer portion.
Because see your prayer.
Yes.
To set aside, reverse, quash the judgment and order 19-24. Whereas I find that the title has been actually given to you by this impugn order.
Yes.
It's only that in the last para there is some confusion
Even, well, Lordship will-
regarding the 2.5
Correct.
acres.
Lordship will appreciate, even otherwise, as per this is land possession certificate, I am the absolute owner. Supposing this is, as this order is quashed, as the order was based on Dobash's order, if this goes, then still my
If
land.
this goes, the DB's order will
That
remain.
also I have under challenge. Because if these two goes, then land possession certificate will remain. I have, Lordship will make, kindly see, page, land ownership certificate. My Lord will kindly come to page 41, along with the sketch map. The sketch is not very good. Page 41,
yes.
NHF 8.
Okay. land
This is the
possession
land, so this circle will remain in my favor.
Okay.
At the time of giving this land owner possession certificate, it was 19 point, but when the four land came, I have given away 1.85 acres, so that I have given, I have received
For the
compensation.
road.
Yeah, I have taken compensation also. No complaint at all, throughout.
This late Sri something Sekose is your father.
Yes, yes. So therefore, this land pata will remain. So therefore, if both SDO's order and Dobash's order is quashed, then it will remain, because they refuse to come before the court explain. After contesting in
So
Dobash's
you are
court.
challenging Dobashi's order also?
Yes, my lord.
Where is that?
My lord, in the prayer, Lord, you may kindly see page 22.
Okay.
Yes, my
See.
Both I have
And the
taken both.
judgment dated 8/6/23.
Yes, my lord.
So where is this 8/6/23?
My lord, page 61. Huh?
60.
Just show. Page 64, 11, page 64. Start from 61, but 11 is judgment is 64. May I read it, my lord?
Okay. Yes, please read.
So the DB court is giving a judgment between the two parties. On hearing both the parties, we learn that there is differences between them. On one side said that it was purchased, and the other side said it was not sold out. And Salio clan also said that their grandfather did not sell the land and they can cleanse themselves. That's why oath swearing had to be given to them. So thereby, the oath swearing is given to the whole male members of Salio clan meaning opposite party, Respondent. And the sworn land will be given to the whole Nipunuma clan. In case if one single male member fails to turn up for the oath swearing, the whole land will be belong to Niela clan, it's me. Oath swearing will be found in NHA. Hence, if Salio clan take the oath swearing and give the land to Nipunuma clan, the case will be closed. The oath swearing land will be given to Nipunuma clan. But since Niela clan also belong to Nipunuma clan, their share will also be there. Further, this is the damaging thing. Further, since Niala clan had built their houses on the land, those areas will not be touched because there are also Nipunima clan. But without the consent of Nipunima clan, they will not be allowed to sell out their land or houses. See, how can they put that condition? Now my Lord will appreciate. This is how the DB court at Suchu Jugda had given out.
Okay. So against this, you had gone to the.
Yes. Oath was not administered. They refused to come for oath taking. Next page, 65. Nobody signed. As per our custom, once oath is taken, sign it there. So they refused to come for oath taking also. So therefore, only we have come against Dobashi order because they say without the permissions of clan member, I cannot sell my house and my land. Where is that law? So I have come before SDOB on that matter. So now therefore, if both the orders are gone, then my land possession certificate will remain issued by the Deputy Commissioner. lord, this is just for list of date if lordship is required. List of dates. If lordship required list of dates.
List of dates, no.
Should initially not date because only verbal, but after once the dates are reflected, I have shown there.
No, it's actually, we can start from the landowner certificate.
Yes, that
Okay.
much, my lord.
That
The
possession
rest are
certificate.
all oral, that is.
That much will do.
So in my respectful submission,
What was that? Wait, let me just mark it. Page, tell me again that land possession certificate.
my lord, page 41. Page 41. Deputy Commissioner has given this, so they have not filed any, my lord will appreciate, against this they have not filed any petition. This is still valid. How can they dispute my property now? If they agree by this 2014, they should have gone to any court and challenged this, the validity of this land possession certificate.
Yes, you had something to say? That's all?
That's all.
Yes, the present, we'll just take it as an appeal, okay? The present application under rule 31 and 32 of the rules for the administration of justice and police in Nagaland has been filed assailing the judgment and order dated 19/2/2025 passed by the assistant to deputy commissioner.
1924.
19/2/24. Yes. 19/2/24 passed by the assistant to deputy commissioner Kohima, Sechu Zubza in appeal poll case number 3/2022 and the
just tell me.
order dated 8/6/2023 passed by the Dobashi's Court of Sechu Zubza Village Council in poll case number 3 of 2022.
Yes.
I've heard learned counsel for the petitioner, Mr. Ashupizo. Stop. This court, by order dated 18/3/2025, has directed that the present application has stated that the notice issued to the sole respondent shall be deemed to be duly served and the petition will proceed ex parte against the sole respondent. Stop. In such circumstances, the present petition is taken up for hearing today. Stop. Okay, we'll just continue. 5 minutes. It's okay, you can sit. And if I make any mistakes on the dates and all, you just correct it. The case of the petitioner is that the present petitioner, as plaintiff, had filed poll case number 3/2022 in the Dubashi's court of Sechu Zubza, raising his grievances that the disputed land measuring 17.47 acres at Tsuru Colony, TSURU, Tsuru Colony, Sechu Zubza of Kohima district, Nagaland, is under the absolute control and possession of the petitioner and his predecessors dash in dash interest, predecessor in interest, for more than last 100 years. Stop. The petitioner slash plaintiff further stated that in the year 1920, one Salyo Nipu of Sechuma village, you just check out the spellings later, okay? One Salyo Nipu of Sechuma village approached the petitioner's great grandfather to lend money in the form of loan for the purpose of cattle business by mortgaging his land situated at Tsuru Colony, Sechu Zubza. The grandfather of the petitioner loaned the said amount with the condition that if the loan seeker failed to repay the loan with interest, then the land situated at Tsuru Colony, Sechu Zubza, shall be given to the grandfather of the petitioner as mortgage property. Stop. The said verbal agreement was witnessed by the then GB of Sechuma village. Stop. As agreed upon, and on failing to repay the loan amount by Salyo Nipu, the right and ownership over the present disputed land was transferred in favor of the petitioner's great-grandfather or grandfather? Great-grandfather. Stop. Para. The petitioner slash plaintiff further states that after the rights and ownership was transferred in favor of his great-grandfather, he had taken possession of the said land and subsequently developed a portion of the land into wet terrace paddy fields. Stop. Besides the terrace cultivation, jhum cultivation was also practiced, and the last jhum cultivation was done in the year 1979 by the family members of the great-grandfather of the petitioner. The descendants of the petitioner's great-grandfather, including the present petitioner, also constructed 3 houses sometime in the year 1970 to 1980 in the present disputed land. And these developments were never objected by any of the descendants of late Salyo Nipu. Stop. These houses are still in existence and are occupied by the petitioner and his family members. Stop. Para. The petitioner slash plaintiff also states that the Sechu Zupsa village had once proposed to construct a road from the government high school Sechu Zupsa to connect with NH29 near Diru Bridge at Suru Colony, which was to pass through the petitioner's land. And as such, in the year 2008, the Sechu Zubza Village Council had approached the petitioner several times to seek permission for construction of the road to pass through the petitioner's land. So, it is therefore seen that the leaders of Sechu Zubza have also recognized that the present petitioner and his family members are the rightful owners of the present disputed land. So, the construction of the four lane of the National Highway Road between Dimapur to Kohima started in the year 2013.
Yes.
And for the purpose of land acquisition, the Deputy Commissioner Kohima published public notice in local dailies inviting claims and objections from all the landowners within 15 days from the date of the said publication. Stop. Being the landowner, the present petitioner, along with other family members, claimed land compensation against their plot, which falls within the present disputed land at Tsiru Colony, Sechu Zupsa. Stop. After identifying the petitioner and his family members as the real landowners, the Office of the Deputy Commissioner Kohima has already paid the compensation amount in full to the descendants of the great-grandfather of the petitioner, including the present petitioner and his family members. Stop. Para. The petitioner submits that after the passage of almost 100 years, the Nipponomiya clan of Sechuma village wrote a letter dated 312 or 1312, wrote a letter on 3/12/2014 to the petitioner claiming ownership, because you have written 3/12/14 and in bracket 13/12. 3/12, I think, to the petitioner claiming ownership over the present disputed land, and also requested for holding a meeting in order to discuss the ownership of the said land. Stop. The respondent / defendant in the said letter dated 3/12/2014 fairly admitted that the petitioner and his family members are in possession of the land for several years, and therefore the claim of the respondent / defendant was without any basis and without any supporting documents. Stop. Therefore, the petitioner and his brothers, in response to the said letter, wrote back on 9/12/2014 that the land and the buildings at Suru Colony belongs solely to the petitioner's family, and that there was no necessity of holding any discussions about the same. Stop. Para. Yes, I'm just coming to the land ownership certificate. An extra 8, no? The petitioner has also produced a copy of the land possession certificate dated 16 September 2014, issued in favor of his father, late Shri Ketunye Sekose, by the Deputy Commissioner Kohima as an extra 8 to the writ petition. Stop. It is submitted that this land possession certificate still holds the field. This land possession certificate dated 16 September 2014 still holds the field and has not been assailed or challenged by the respondents / defendants. Stop. Acha, why did you file that case before the DB's court?
Because
How?
they can destroy our forest.
Acha, where is that? Para? Six. Okay, then para. On this 5 and 6, I think 5 and 6. On yes. On 11/10/2022, this Ningomezo Nipu is the defendant, is the respondent. On 11/10/2022, the present respondent / defendant, along with 3 others, intruded upon the petitioner's land and started cutting the jungles and claimed ownership over the land. Stop. Against such illegal cutting of plants and destruction of the jungles, the petitioner submitted a complaint on 17/10/2022 to the Subdivisional Officer Civil, Sechu Zubza, seeking intervention. Stop. The SDO Civil advised the petitioner to file a complaint before the customary court, and accordingly, the petitioner and his brothers filed a complaint on 7/12/2022 before the Dobashi's court, and the same was registered as Paul case number 3 of 2022 before the Dobashi's court, Sechu Zubza. Stop. Para. The Dobashi's court of Sechu Zubza heard the matter, and on 8/6/2023 passed the impugned order to the effect that all the male members of the Salio clan can claim right over 50% of the undeveloped land by way of swearing customary oath, with a stricture that if any male member fails to take the oath swearing, then the whole land shall belong to the Niyale clan. Stop. However, none of the members of the Salio clan took advantage of the Dobashi's court's order dated 8/6/2023, and they did not come to swear any oath. Stop. Para. Being aggrieved by the decision of the Dobashi's court dated 8/6/2023, the petitioner filed an appeal before the Deputy Commissioner Kohima on 6/7/2023. Stop. The Deputy Commissioner Kohima endorsed the matter to the Court of SDO Civil Sechu Zupsa, and the same was heard and disposed of by the Assistant to the Deputy Commissioner Kohima on 19/2/2024. Stop. Para. Being aggrieved by the impugned judgment and order dated 19/2/2024, the petitioner has come before this court. Stop. Para. Learned counsel for the petitioner, Mr. Ezo, has taken the following grounds to assail the judgment of the SDO Civil Sechu Zupsa dated 19/2/2024 dash small one. That the learned court below, after perusing the documents of title of the petitioner, after perusing the documents of title of the petitioner, accepted and recognized the ownership of the petitioner for the last 100 years over the disputed land. And yet, the court upheld the decision of the Dobashi's court, which is erroneous and needs to be reversed. Number 2, the learned court below, without assigning any reason, has affirmed and confirmed the order of the Dobashi's court passed on 8/6/2023, and therefore the judgment dated 19/2/2024 is liable to be set aside. Number 3, that the learned court below, after coming to a conclusion that the petitioner's family has been in occupation for over 100 years, could not have directed that the remaining undeveloped portion of the land, 2.5 acres, be in a discourse between both parties, or that any disputed parties for any future avocation as per their customs and traditions. Stop. And therefore, the said observation is not sustainable in the eye of law and is liable to be set aside. Stop. 4 or 5? Next point. The learned trial court, while pronouncing, the learned court below, while pronouncing the impugned judgment dated 19/2/2024, has not applied its mind judiciously and without citing any genuine and cogent reason for the decision, has simply affirmed the judgment and order passed by the Debashis court, and hence the impugned judgment is perverse and liable to be quashed. Stop. That's all? Stop. Para. This court has considered the submissions of the learned counsel for the petitioner and perused the impugned judgment passed by the Debashis court, as well as the judgment of the STO Civil Sechu Zupsa, passed in Paul case number 3 of 2022. Stop. This court has observed that the learned court below had framed 4 questions to be decided. Dash. Then you just quote these 4 questions, okay? Number 1, 2, 3, and 4. Stop. Para. In considering the first question, the learned court below came to a finding that the appellant/petitioner's family has been an occupation for over 100 years, developing and managing the disputed plot of land. Stop. The court also held that it is clear and apparent that the respondent could have objected to the development activities of the appellant/petitioner for the past 100 years, however, no such claims or objections were raised or brought before any competent authority. Stop. The court held that the developed area within the disputed land belongs to the appellant/petitioner, since the appellant had incurred all the expenses for all the developments. Stop. However, with regard to the second question, the learned court below stated that since both the parties in dispute do not possess, this land possession certificate was not produced before the. Oh, then why is saying that?
He said after examining all documents, he said
that since both the parties in dispute do not possess any documentary evidence pertaining to the claims, and therefore the portion of land and therefore the remaining undeveloped portion of land, being 2.5 acres, should be in a discourse between both parties for any future avocation. What is future avocation? For any future avocation, as per customs and traditions. Stop. In this respect, this court has seen that there is already a land possession certificate dated 16/9/2014 in favor of the petitioner, and the same was also produced before the learned court below. Stop. This 19.32 acres is the entire area, isn't it?
He himself had done in paragraph 3, page 69. The judge himself said, I have released this document position, paragraph of his judgment.
That the land possession certificate.
Then how will he say that?
Yes.
I don't left the administrator on. 19 entire land. But after giving away all land, I have released it.
Yes, what did I say? Last line. Learned court below. Stop. And the learned court at paragraph 3 of the impugned judgment has stated that, then you quote this paragraph 3 in inverted commas, okay? Stop. This court is of the view that the learned court below could not have come to a conclusion that there are no documentary evidence pertaining to the disputed plot of land, as the land possession certificate dated 16/9/2014 was produced before the court, and the said land possession certificate certifies that the appellant/petitioner is the absolute owner of the present disputed land measuring 19.32 acres at Sechu Zubza, 0 colony. Stop. Therefore, this court is of the view that the finding that the appellant/petitioner is the owner of only the developed area within the disputed land is perverse and needs to be interfered with. Stop. In view of the discussions made above, and in view of the land possession certificate dated 16 September 2014 in favor of the petitioner, which holds the field till date, the impugned judgment and order dated 19/2/2024 passed by the SDO Civil Sechu Zubza, and the judgment dated 8/6/2023 passed by the Dubashis Court of Sechu Zubza in poll case 3 of 2022 is quashed and set aside.
Our Puko, Kevin, and not forgetting Vincent. Court 30 is a bond. Court 2 is over.